would say let's get started. I wanted to start by thanking all of you for joining us in this panel organized by AWO on reforming the Adtech ecosystem, options for chains beyond the Privacy Directive, DSA, and DMA. So I hope that you've all done the required reading, which was the study undertaken by AWO on behalf of the European Commission. It's only 280 pages. It was published in January, so if you had done like 3 pages a day, you'd be there by now. If you haven't read it, I mean, summer's coming up, makes for good beach reading, probably. So I'll start off by giving a little bit of an introduction about the study, which kind of covers the topics which we'll be focusing on during this panel. So to everyone's big surprise, the study found that the digital advertising market's impacts on privacy, democracy, competition, and the environment shows that it is unbalanced and unsustainable. It's unsustainable for individuals whose privacy is jeopardized by a focus on profiling and tracking. You've got massive data sharing, which comes with risks to one's security from the potential for data breaches and data interception, a risk that's heightened by the fact that one's data is shared in so many different hands. One might have forgotten this, but even Edward Snowden revealed that cookies had been used for state surveillance by the NSA. On top of that, it's really difficult for individuals to have full control over what happens to their data when it's used for digital advertising. But it's also unbalanced and unsustainable for the market's main customers, advertisers and publishers. They also complain about lack of control. They complain about lack of transparency, lack of competition. High levels of fraud have a major impact on both marketing budgets and publisher revenues. And we have a situation where both advertisers and publishers feel highly dependent on large platforms, but aren't very happy about it. During the interviews that we undertook as part of the study, advertisers and publishers described large platforms as frenemies. They described having an abusive relationship with them, or even better, a love-hate relationship without the love. So all these problems have major impacts for society as well. We know that major disinformation providers are ad-funded, which has an impact on democracy. And the large amounts of data processing means high energy use, means that digital advertising also has a high environmental impact. The study also found that legislation such as the GDPR, the Privacy Directive, the DMA, the DSA, and Consumer Protection Law all address these problems only in part. And so there's like major, still big gaps in the EU's framework dealing with these issues. And because of the market's rapid evolution and complexity, there are also big barriers to enforcement. So we've brought this panel together to take a look towards the future, to answer the question, how do we complete the EU's framework on digital advertising? Whether through new laws, new initiatives, or through funding or other things. And so the goal is to chart the way forward for future EU legislation to make the digital advertising market more balanced and more sustainable. So I'm Nick Botton. I work at AWO, and I'll be moderating this panel today. AWO is an agency with a base in Brussels. We work with our clients in the field of digital rights. We have a litigation team, a research team, a data protection compliance team, and a public policy consulting team. To my right, we have Peter Eberl, who is Deputy Head of Unit Cybersecurity and Digital Privacy at the European Commission. He has been one of the key people working on the privacy regulation since its publication, maybe the key person. To my left, we have MEP Alexandra Geese from the Greens EFA group, who is a strong advocate for privacy and platform regulation. She was Shadow Rapporteur for the Digital Services Act and still is a member of the Tracking Free Ads Coalition. Also to my left, we have Angela Mills-Wade. who is Executive Director of the European Publishers Council, a high-level group of chairmen and CEOs of leading European media companies. She'll be speaking for a group that has a lot of skin in the game in this context, given the impact that changes in the market have on publisher revenues. And then finally, to my right, we have Johnny Ryan, who is Senior Fellow at the Irish Council for Consumer Liberties. He has been one of the loudest voices for reform of the digital advertising market. So we're going to take this thematically. We're going to go kind of step by step, area by area, starting with GDPR privacy, then going into DSA, and then finally to DMA, kind of looking at the gaps in all of these frameworks and how they can be completed. So we'll start with GDPR and e-privacy. So partly due to its complex and duopolistic nature, digital advertising has not seen that much GDPR enforcement or e-privacy enforcement. You have this bottleneck problem in Ireland, which we're all familiar with. But you also have the risk that fines might not be dissuasive enough. So I'm going to start with Peter. We do have something on the table to kind of complete this part of the framework, which is the e-privacy regulation. But it was published in 2017. So in terms of the digital advertising market, that's basically a century ago. Do you think that the proposal is still up to the task, particularly in light of the impending end of third-party cookies?
Thanks, Nick. Does it work? Yeah. Welcome, everybody. So maybe one clarification. I haven't been on the file since the beginning, only joined later. And as you described, I think the current situation is unsustainable. I think it benefits mainly two companies, and it's difficult for publishers, for advertisers, and for consumers. And I think there's no panacea to solve that, and there's not one single piece of legislation to solve it. But I think the different pieces of legislation, they are complementary and then to solve the issue. E-privacy, I think there is an important element in that. And it is already there, the directive, and which is being enforced by some member states or some authorities, most notably the CNIL in France, which imposed some significant fines for infringements of the relevant provisions on cookies in the e-privacy directive or in the French transposing law. And the e-privacy regulation tries to adapt and modernize the directive in that respect. The key element which is at stake regarding online advertising is Article 5.3 of the directive, Article 8 of the proposed regulation, and that is still up to date, how long it has been proposed. Because this is about the use of processing and storage capacities of terminal equipment, so any device which is connected to the internet, or the collection of information from that device. And for online advertising, I think everybody agrees that that can only happen with the consent of the user. And the challenge of the regulation and of the negotiations in that respect is how to make that as user-friendly and as most efficient as possible, also to ensure that it can be enforced by the authorities. And so these questions haven't gone away, and they are being discussed in the trilogues with the co-legislators. Let's say there are some additional elements which were introduced in the Commission's proposal, how to facilitate the user choice regarding this consent. I think those issues, they have to be updated because there have been market developments, but there are suggestions in the Parliament's position and in the Council position, which I think are good ideas and which are being discussed and which should be somehow brought into the final text. So one example is, for instance, the Parliament had proposed to have default settings in the browsers. And this is something which is going to happen maybe now, because Mozilla and Apple have already these default settings. Google has announced to do it. So maybe the market development goes into that direction. There are other useful elements in the council position, also in the parliament's position, which are being discussed. So I think the basic structure of the proposal on that provision is still valid. But of course, it's important to update and to modernize that, but that can be done in the legislative process.
So you'd opt to. So you think so? So for instance, one of the issues is that like a lot of these new digital advertising tools, these like pro-privacy solutions, don't necessarily rely on cookies, right? And so they're not placing information on the user's terminal. So I think there's an issue of scope there to some extent, and you're sort of implying that this is something that should be dealt with in the legislative process of the e-privacy regulation rather than through a new law.
Well, it depends. I think definitely e-privacy directive and regulation is not limited to cookies. It's any kind of tracker which has access to the device and extracts information from the device. So all these elements are governed by that, and so cookies is just a pass pro toto for a bigger thing. If things happen purely outside the terminal equipment, without any collection of information from the terminal equipment, then maybe it's a different provision, and then there may be different laws applicable, because then we may be in the area of GDPR and not of e-privacy. But of course, we must also keep in mind there shouldn't be any circumvention of the e-privacy provision. So if there is circumvention of something which is clearly covered by e-privacy, then the authorities will also intervene if there's a circumvention of those protection.
Okay. That is fair. I want to turn to the larger kind of overarching problem, which is more structural when it comes to privacy regulation. That has to do with enforcement. So even if you have an e-privacy regulation that's whose scope is perfect, who's like totally future-proof, let's say, you still have this this issue that digital advertising is very complex, and you have this issue where a lot of the biggest players are based in Ireland, so you have this bottleneck problem. I wanted to turn to Mrs. Geese to ask, so you worked on the Digital Services Act, and the Digital Services Act, like the DMA, has this regime where certain categories of companies, because of their size, because of their importance, are subject to a special enforcement regime. Do you think that this is something that privacy regulation should have as well?
Yes, I do. I think that would be a very interesting evolution for privacy regulation. And I think what we need to see here is not only the details of how to better enforce particular regulations or particular provisions, but we need to see a little bit the big picture, and that is the total power asymmetry between the two companies that were mentioned and basically everybody else. The publishers, consumers, I would say citizens. Because what we do need to see is that this kind of business model fosters polarization in the internet, because it's not only about targeting advertising. Why are we so adamant about advertising? From one point of view, because it's basically strangling the publishers, so putting at risk, jeopardizing our free press in the long run. But the other problem is that the same data profiles that are used to target advertising are also used to target content to people, to deliver specific content to people. And that, together with the algorithms that foster polarization and possibly toxic polarization to keep people hooked to the screens and to the platforms to look at advertising, means that we're losing democracy. There are studies by a Swedish institute that does research into democratic or autocratic regimes over the world. It's called the Varieties of Democracy Institute, that says toxic polarization is one factor that all states globally, that autocracies have in common. And autocracies are on the rise. So what we're talking about here is not only protecting individuals from being tracked, but protecting whole societies from turning to autocracies rather than democracies. And we're seeing in Europe, we've seen Hungary and Poland, and then now we're seeing Sweden, we're seeing Italy. It has all quite a lot to do with polarization if you look at that debate. So this is what we're trying to tackle here. Therefore, I think the specific solutions are very important and better enforcement is very important, but we need to tackle the whole system. And there, I think DSA and DMA have sort of started the intellectual work to say, okay, what we're really addressing here is the power asymmetry with the definition of very large online platforms and the DSA, with the gatekeepers and the DMA. And that is the way we need to go. The problem is that we're not going far enough because we didn't have enough knowledge, because of the complexity, even for policymakers and for courts, it's difficult to understand how entrenched and embedded the power of these companies is right now. I don't know if anybody was here yesterday for the keynote where Julie Cohen spoke about infrastructure being embedded and therefore invisible unless it breaks down. And this is what we're facing here. And this is, I think, what we need to tackle, what DSA and DMA in a way started. I think here we need to be clearer and we need to really define a way to protect privacy, to have data protection, but more in terms of protecting society against monopoly power. And that is a very economic issue as well. And this is, I think, the way we need to go. Look beyond just data protection for the individual, think about privacy as a protection for democracies as a whole. Because my fear is a little bit that when Google comes out with a solution where you can't trace the data to the individual, but just to a group of 100 people, it will become very difficult to apply GDPR, but they will still be able to manipulate entire societies. And I think this is really the risk we are facing, and therefore, yes, we need to address this in a more structured way, to think about these companies as some kind of infrastructure, to think a lot more in terms of antitrust, of competition as a basis for a free world and for democracy.
Thank you. When you talk about polarization and rising kind of extremist thinking across Europe, that hits home, obviously. I'm half Italian, half Belgian, so it's problems on both sides. I want to turn to Angela because the thing about the GDPR is that, of course, it doesn't just apply to large platforms, and when we talk about a market that has competition problems, we're not just talking about having these like two huge companies which have a huge influence over how the market operates. We're also talking about the other companies that are in this market and which kind of struggle to compete on the same terms. So I wanted to turn to Angela to ask, what's been the experience of publishers in complying with the GDPR and Privacy Directive, particularly when it comes to their dealings with large platforms and their competition with large platforms?
Well, the GDPR has had a huge impact on publishers, notably in the advertising sector, but not only, because obviously there are other areas in the businesses that it affects. I think it's been a bit of a disappointment, to be honest, and because I think the publishers really felt that it was going to be a game changer in terms of giving them more control over their relationships with their consumers, and really to help differentiate their offer to the consumers, their value proposition. We will treat your data processing fairly, and in return you get access to journalism and entertainment and other forms of media. And this didn't really happen. And it's not going to happen under GDPR, because what GDPR has done has already been very well expressed, has allowed the dominance of two platforms in particular to perpetuate. And it wasn't designed to deal with the advertising ecosystem and the complexity of the advertising ecosystem, with the number of intermediaries, many of which publishers work with. But we feel very much in a kind of dependent, a situation of dependency. We have to depend on the large platforms. We also have to depend on intermediaries that the advertisers are working with. And the advertisers are spending most of their money on the platforms, not with publishers. So the whole thing has evolved in a disadvantageous way. And of course, enforcement has been very disappointing. I think we expected more, and that hasn't happened. We don't really know, unless the GDPR is reopened, and I know inside the European Commission it's a bit of a holy cow and nobody's prepared to touch it. But I think it will have to be at least looked at again, along with e-privacy. Peter's been very open about the need to look at market developments. We're entering the age of hyper-personalization enabled by artificial intelligence, and we're only just starting to see that. And as those technologies develop, they will develop in such a way that will move away from what we understand from the cookie-based, tracking-based, where inferences and all sorts of emotions and goodness knows what else will be extracted very easily and will be used very effectively for targeting content and targeting advertising.
So yes, you're absolutely right. Reopening the GDPR, whenever someone says those words, it's like, oh gosh, don't say that.
Nick, do you mind if I respond? Go ahead. Because what Angela is saying is, I think, pretty seismic. First, it is a sign of this power problem, of how far we've come in the last half decade, that publishers are on stage saying we want enforcement. This is good. And you've been saying it for a while. There was a time when you weren't saying it, this is good. And the advertisers are saying we want enforcement. This is a total shift from where we were half a decade ago. It's also a way of saying the last half decade has been a total failure. This is a room full of failures, some knowing and complicit, some accidental, in my case, ineffectual. Let's think about how we got here and why this title says what it says. What was it? 2 weeks before the GDPR was applied, Google wrote to all of your members, it's now well known, you've made it clear, rightly. And it said, okay, you've been waiting for our GDPR solution. Here's what we're going to do. We're going to take all of your data and we're going to make it ours. That's a paraphrase, but I don't think I'm doing them a disservice by putting it that way. And they got away with it. They got away with it because there was no clever, decisive, early, I wouldn't say enforcement, early grumbling from the enforcers. There was no nudging. There was no winking. The enforcers did not bestir themselves not to enforce, but to even hint that they would enforce. That whole incident passed just like all of the original layer of consent spam we had leading up to the GDPR. There was no signaling from the enforcers that enforcement might happen. I remember meeting one enforcer a year before all of this and saying, if you don't signal, we're going to have a market failure here. And they said, well, we're not going to do anything until we have the e-privacy regulation. And they were true to their word. They still haven't done anything. Now, where are we today? There was a DMA workshop, Digital Markets Act workshop. I'll shut up after this. 2 weeks ago in this city, organized by the European Commission. And Tim from Meta did exactly what I'm doing now. He filibustered to eat into question time. And his filibustering went like this. DMA, Article 5.2 about combination of data. We're going to need consent. What is consent? What is consent? And people are so consent fatigued. Please think about the people, won't you? How can we master this consent problem? Because we care about the user. And you know what disturbed me? I thought he did a very good job. I'd hire him. I thought he was great. But the commission was chairing that meeting. And no one from the Commission tittered or cracked a smile. No one said, but Tim, isn't it true that you used to organize consent workshops to design, it wasn't your unit, to design perfect consent requests? You used to invite us in for these workshops. They were big events. It was wonderful. And then didn't it turn out that you weren't actually using consent? You were actually using a kind of a consent bypass, as Max would call it, contract. So we're back to where we were. There's no signaling of backbone. We're not even asking enforcers to enforce. We're asking them to start signaling potential enforcement. And until we get that, we're nowhere.
By the way, we did write to the EDPB the day that Google did that and asked them to look into it, and they didn't.
Johnny, I don't know what you're talking about. Just this week, we had a huge fine, given to Meta, 1.2 billion euros, and earlier this year as well, fines to WhatsApp and Instagram. It sounds like the GDPR is working just fine. It sounds like it's finally, coming to fruition. It's finally happening. Aren't these kind of proof that the GDPR is working?
This is a sensitive topic. It's sensitive because the momentum that carried the GDPR through Trilog, a lot of it was created by Edward Snowden and his revelations. The political realities are now a little bit different. I'm not saying that there should be a lax approach to the transfers of data to any third country. I think that's a sensible provision. But as we hit this 5-year anniversary, we don't want to be hanging it on this question of EU-US transfers yet again. It's an important question, but I don't think it's the central one. Also, it's obvious that when the FTC did fine Facebook in 2019, $5 billion, the company's share price went up the next day. So fines have never been the thing. If they were to be the thing, they'd have to be unimaginably large. What matters is the compliance order. And on this particular question, it isn't a distraction. It's just a separate thing. I think it's a separate thing to what we're discussing here.
Okay. I want to give people the opportunity to respond to anything that's been said before we move on to DSA-related issues. Yep.
Maybe just two remarks on what Angela and Alexandra said. I think Alexandra mentioned that competition and antitrust law could play a role in protecting against this oligopolization, monopolization. I remember when I did media mergers in DG Competition, of course the standard was always competition issues and market impact. But one of the, let's say, the side products was always some kind of pluralism as well. And I think that is definitely a possible element also in competition cases, that this kind of opinion power is somehow also constrained. Angela, I think I agree with many things you said, but I think that GDPR is blamed for the consolidation of an oligopolistic position. I wouldn't go that far. I think that is not, I don't see any causality there. I think
it's an exacerbation.
Okay, but I think there are probably other factors which have been much more important in that process than GDPR.
Okay. Next, we have these new laws, right? The Digital Services Act in particular, which is coming into force soon. We have a few important things that are related to digital advertising, these kind of things that are tangentially related, like the notice and action framework for illegal content, the risk assessment regime, which is applicable in part to disinformation. We have a requirement for users to be informed about the parameters that were used to target them with ads. And finally, we have the ban on targeted advertising to children and based on sensitive data. I want to first start talking about this disinformation piece. And I want to turn to Angela. So one of the big problems with disinformation is that you have these websites that make disinformation and which are ad funded. And I wanted to ask Angela, so why is it so lucrative to use digital ads to fund disinformation? And do you think that the code of practice on disinformation goes far enough to fix this overall problem?
Well, I think the code of practice is interesting. Doesn't really address all the issues, and its effectiveness has not yet been monitored properly. I think that starts in September. I think there's a project, Kantar is going to be doing that. But I think what the code of practice does is exposes the fact that because the platforms do not have legal liability for what they curate and distribute, means that there has been a proliferation of disinformation, misinformation, harmful information, and indeed illegal content. So I don't think that's going to be solved anytime soon, neither in the United States nor in Europe. There doesn't seem to be any appetite to increase the legal liability. In the DSA discussions, it was set at a similar level really to today, just adding some clarity around obligations. The reason why it's so lucrative is because people like sensational content, and unfortunately it plays to human traits of enjoying sensational content, and they get more hits. So even if it's just untruthful, misleading or harmful, very often that's the kind of content that gets shared, goes viral, and that the whole thing perpetuates, and the algorithms support that amplification. I won't go into the societal things that Alexandra mentioned. She did it very clearly. But the advertisers, of course, are attracted to the platforms because they have a lot of data and they know how to manipulate it. And, of course, there is reputational damage for brands to land alongside such content. But nevertheless, they're there. And there are many other advertisers, maybe not the top ones that we all know and love, but there are many others who are very happy. Or they don't even know. That's the other problem. Through programmatic advertising, often ads just drop in, and there is no control over that for a lot of the peoples who don't have the resources to monitor.
Just to explain, I think there are different reasons why disinformation goes viral. One of them is it's very cheap to produce. You just get a picture and a false quote or something, and you just push it out. And this is why producers of disinformation feed the algorithm, because they can push out stuff every 10 minutes, basically, while journalistically curated content costs. It's expensive, you need to pay someone to do this, a very qualified person. So that's quite expensive. And then it's not only that people like it, it's what people engage with it. It's not necessary. This is what Frances Hogan told us very, very clearly, the Facebook whistleblower. People don't get to see what they like. They get to see stuff they engage with. And that might be stuff that you don't like. But you say, oh, look at what they are doing again. And I have to share this with my friends. I can't believe this. I have to look into this. It's not necessarily what they want to see, but what they engage with, what they share. And this gets picked up again by the algorithm. So the algorithm optimized for a lot of stuff being put out by the same subject, and obviously people engaging with it. And this is why disinformation goes viral a lot quicker than facts. It's not only human nature. Human nature doesn't help in that case, but we've had that in traditional media for decades. Everybody knows tabloids. That's the same kind of idea. But there are very few countries where tabloids are considered the main source of information or are really determined for what the political landscape looks like. They are part of it, but there's also serious information. What we are seeing in the internet is that disinformation is sort of pushing away the serious information, because media, as well serious media as well, are sort of forced to jump on that train and to have at least clickbait titles. Even if the article is well researched, the titles are very, very often a piece of disinformation. That's one aspect, and then the advertising aspect comes in, that brands don't have control over where ads land. So they end up funding these sites even if they don't want to. I talk to big advertisers, they say, we have guidelines. We have very clear guidelines for not having our advertising close to disinformation content, covert-like content, whatever. And it's just not being respected. And so we are spending millions not only on the advertising, but on companies that try to find the ad fraud, that try to find our ads being placed, because that's a brand safety issue. It's a damage for our brands, but they can't control it. And those were some of the biggest advertisers. And this is why so many money flows into this disinformation site. So you don't even need, a political malicious actor or an external malicious actor. It's just to become a business. That's the real problem. Additionally, obviously, if you want to do disinformation for political purpose, the data, the surveillance advertising is absolutely the perfect ecosystem for placing your content exactly with the people who are likely to believe it or are likely to slowly move over. People don't look at content that is completely far away from their convictions, but they would look at content that is maybe not exactly what they think, but that picks up some of their ideas. And then they can slowly be led to more extreme ideas. And this is how it works. And this is why disinformation has becoming such a pandemic in our sites, because it's so heavily funded even by the big brands.
I think you kind of pointed out a really good point that the EU often has these market-based solutions to these types to problems in general, right? Whether you were talking about the environment, digital, things like that, and to kind of enable a market solution, you need transparency, right? So the most obvious way of trying to prevent ads from appearing next to disinformation is to make sure that advertisers know where their ads end up, right? I mean, that's clear. In the conversations that I've had with people in the market, I've heard that the market has resisted the idea of a universal transaction ID. So not something like a cookie, something that's associated with the ad in question rather than the user, right? So that an advertiser knows, okay, I paid this much for this ad and it landed here, right? And I have a full list of everywhere that my ads ended up. This is something that the market doesn't have. I mean, this is kind of, it's a little weird. It seems kind of like a basic thing that you should have in a market, but the idea is, it's so complex, et cetera, et cetera. Another kicker, apparently people in the market have said, oh, well, we can't do something like that because of the privacy implications. It's just a little ironic. I wanted to turn to Johnny. So another way in which funding disinformation through ads is kind of lucrative is because of the audience arbitrage problem. And this is something that you've talked about quite a lot. So I'm a user. I go on, I visit, a website like The Guardian or like a paid publisher website like the New York Times or something like that. And a cookie is associated to me, which demonstrates, oh, I'm the kind of person who pays for my news content. So I have money, right? And that means that I become a kind of high value user. And that means that when I go on another publisher website, the intermediaries in question know that I'm a user with money. So that means that when I go on a disinformation website, the ads that end up here, right, on that website, end up more expensive, even though I'm viewing disinformation, right? And so that's part of how disinformation gets funded. I wanted to ask you about one of the solutions which the study proposes that the Commission explore, which would be to ban intermediaries from being data controllers. So this is a concept which I didn't come up with this term, but you can call it forgetful advertising. So an intermediary would act as a processor on behalf of advertisers and publishers, but they wouldn't retain any of the data that they use. So they use the data for each transaction, and then they just delete it. They never combine it with any of the other data that they use. They just delete it. There's simply a funnel for ads and for data between advertisers and publishers, but they don't retain anything. Do you think this is part of the solution?
I think it's a very interesting idea, and it's attractive. But it relies, there is a but, it relies on investigative supervision that can take a look into the intermediary firms. The biggest would be Google. Meta's in there too, and so is Amazon, often not mentioned in this context, but Amazon's one. You need to be able to look into those firms and check to see that they're not using those data for their own ends. I'm not sure I would have full confidence that that would actually happen. In fact, I'd be quite confident that it wouldn't. So I like the idea. I remember applauding you for it when you came up with it. I don't know how workable it is. If even the basics aren't enforced, I'm not sure how this complicated idea can be enforced. I think there's an easier solution to all of these problems. We've got, between thousands of companies, an external data free-for-all, just throwing data around the place. I'm not sure adding in a transaction ID is the solution either. The audience arbitrage happens because you can be followed from worthywebsite.com to thrashyconspiracyclickbait.com. It's because you can be followed. The ability to follow people around the internet is actually the problem here. I'm not saying that should never happen where there's a particular case and someone wants it to happen for some particular reason. But if you have a free flow of data between thousands of companies about what everyone is doing, where they're standing, what they're reading, watching, and listening to, you end up with audience arbitrage, and you end up with the data that allows everyone to be micro-profiled and targeted and discriminated against. So let me suggest there's one word that can solve some of maybe all these problems, and I can't take credit for it. It comes from Barry Lynn at Open Markets. Barry's very good at summarizing a solution in one word. And Barry uses this term now. He says, non-discrimination. That unless you want to be treated differently, you should be treated the same as everyone else. You being a person, you also being a business partner, you being a gig economy employee, everybody. We were promised that the internet would give us some new science to allow personalization. And we're seeing that problem of unsolicited personalization. And it's causing market problems, it's causing trust problems, society problems, and it's killing journalism.
I think it's good that you mentioned this because we actually have another suggestion in the study, which I think could be kind of fit this idea, and that's the idea of having having the commission work to establish a single interface where users can set their preferences for digital advertising. And so this would enable users to turn off targeted advertising altogether, or to kind of create an avatar which kind of where they list, hey, I want to receive ads on this topic, this topic, this topic. And so this is kind of similar to the Article 10 of the e-privacy regulation, in that although that is limited to the browser. The single interface would be something that applies kind of more broadly, to account for the ads that one receives when they use apps and things like that. So it's either something that would work, on operating system level, or that would kind of work through like a centralized kind of website where people can kind of set their preferences. And so this is obviously quite a technical issue. So we're like it's something that needs to be worked out, that where industry would have to be involved in creating. I wanted to ask Peter, what do you think about such a tool? What do you think would need to work how would we make it easy to access, use, and understand? Because this is kind of one of the key points of the privacy regulation as well.
Thanks. Just one clarification, maybe. These are, of course, suggestions by the contractor.
Yeah.
This is not the Commission's position. This is
Sure.
suggestions made by the contractor. I think, and you mentioned this is, let's say, inspired or similar to Article 10 of the Commission proposal. I think Article 10 probably opened the discussion on this issue, but as I said before, things have evolved, and I think we have to think about other things because some things have been overtaken by the market development. Article 10, I think, basically foresaw an obligation for the user to make a choice when installing a browser, whether they want to accept cookies or trackers or not. I think things have evolved and we have to think about more sophisticated things now. And this is one of the issues which could be considered. I would see it in simplistic terms as a kind of consent management. These are issues we are discussing with the co-legislators. And I think it makes sense in order to address this cookie banner wave, which I think is unsustainable and unsatisfactory. I think it's frustrating for the users, all of us. And I think it's also frustrating for the publishers because if they have dissatisfied customers, they will not go to the websites, and it's also not satisfactory for the advertisers. So I think we have to find a solution how that can be made more user-friendly and more effective. I think any such consent management or single, what did you call it? Single interface should be only optional or voluntary for the user, so no obligation to use it. And in order to make users use it, I think it must be very trustworthy. And the management must convince the user to use it and install it. It must definitely not create any gatekeeper position. So I think that was one of the criticism of the Commission's proposal. I think it was not intended by the Commission as such to create any gatekeeper position, but it was put forward by many players and stakeholders that this could create gatekeeper positions for the browsers because the perception was that this would be installed on the browser and the browser would somehow manage the consent and would then discard some publishers and let's say put them out, and that would have, I think, contributed to a consolidation of the market power of the browsers, and then knowing that some browser manufacturers are also very active in the internet online advertising market. So that should definitely be avoided. And this is, of course, true for both browsers, but also for operating systems, because in the app market you have the same, or ecosystem, you have the same issue with operating systems as you have with browsers in the browser market. And it should also not lead to, let's say, any gatekeeper position for any new consent management platforms. If they were imposed somehow, I think that would also pose a problem. It should allow the user to make a kind of detailed choice, not only yes or no. It's already a question whether you can give a blanket consent for all trackers, I don't know. But I think it should also allow users to choose, for instance, publishers whom they trust, to whitelist them and to allow cookies of those publishers and also of the partners of those publishers. And what we've seeing now in the market is that when you see this, when you make your kind of dedicated choice, that some publishers, they only want to use cookies for instance, simple or basic ads and not any more personalized ads. And if a publisher has partners and makes it credible and trustworthy to the user, that they only work with partners who respect this kind of charter of for what purposes this is used, I think then the users may give them the consent, but it's the user's choice. And of course, what also has to happen then is that the choice of the user must be mandatory for any website and any browser and operating system, so that this is then transmitted immediately and there's no possibility to delay. And if a user has chosen to accept the cookies of a certain publisher, then that must be respected by the browser and by the websites. I think this is how this could work. I think it's a very complex technical issue, but I think the basic idea of having such a system could definitely help to simplify and get rid of these cookie banner wave and these complicated cookie banners. And of course, also on those banners, if the publishers continue to ask, there must be some simplification, but I think that's another question.
I think you've kind of targeted all the problems, which mean that, you know, when you're talking about like not creating a gatekeeper problem, you know, allowing the whitelisting of publishers, and even like getting users the transparency that they need to whitelist a publisher, to know that like, oh, okay, if I give my data to this publisher, they're going to use it correctly, and it leads to one of my favorite publishers, you know, getting more money, right? This is all I want to do personally. You know, I follow these like small blogs, right? And I turn on targeted ads for them. I hate the ads. The ads suck, you know? So it's, if I had the option as well to be like, I want to see targeted ads on this website, but I only want to see ads for this type of stuff. I think that from a user perspective, it would be, you know, much better. I want to turn to Angela, because obviously this kind of issue has a big impact on publishers. You know, the question of Article 10, the question of whitelisting. Yeah, like how do we make that work from a publisher standpoint?
I'm not sure. We're in Area 42, and 42 is the answer to the ultimate question in the Hitchhiker's Guide to the Galaxy. And I'm never quite sure we ever found out what the ultimate answer was. But I think it has a kind of attractiveness of simplicity, but it doesn't really address the kind of ecosystem we're in now. And I'm not sure consumers really want to have to make all those choices at the same time. You know, they might hear about a new publication, or, oh, you know, this newspaper's got this amazing feature today, and they might never have been to that website before. So there has to be a system where certainly the publishers have direct interactions with their users and don't have choices imposed upon them beforehand. So there have to be kind of contextual, in-moment decisions. I can't imagine who would produce this interface. Who's going to do it? It could be an advertising media industry funded solution. We have the European Digital Advertising Alliance, which exists already. It was formed at the time of the first e-privacy directive, really to help consumers make informed choices and manage their cookies that were used for the purposes of targeting advertising. And that is a system which is under review at the moment because of the Digital Services Act and the transparency requirements in there. But it would be an enormous investment required. It's not just a technical problem; it's a monetary problem. And the browsers Peter mentioned. There's no coincidence that browsers and operating systems are core platform services under the gatekeeper regime in the Digital Markets Act.
May I check, Angela? When you say the EDAA was helping people with their cookies, do you mean ad choices?
Yeah, your online choices.
Your online choices. Okay, that's.
It was set up a long time ago.
Yeah, but it's not. I mean.
We're not really here to discuss the EDAA. I'm just saying that there is an organisation that brings together advertisers, agencies, all the media, broadcast and print, and the IAB, so that the whole ecosystem is in there.
But the reason I mention ad choices is it's the most seen and least recognised icon ever created. So it's a model of what never to do again.
The research that the EDAA carries out says something else, and
I've seen the research. Yes.
Yeah. So I mean, you know, your research might say something different, but you know.
I mean, we could ask people in the room: do they know what the ad choices icon is? It's a room of privacy experts. 4 of them might say yes.
I would think that most people. I mean, some people might. I see one hand. I see two hands. Three. Yeah, see? Everyone knows about it. Half the room. Alexandra, you wanted to say something?
Yes, I just wanted to remake the point. I think having people make this very differentiated choice about what they want to see, I feel like being in a parallel universe. I mean, have you ever been out there with real people when they, I mean, even people who know we are paid basically full time to understand the system. And I certainly don't understand all the complexities of it. I don't know about you, but I don't. Normal people have absolutely no idea about what's going on. They see a cookie banner or any kind of instrument that gives you choice and say, okay, what's the easiest choice to get to the article? Because you have to do it anyway, and they go for yes. I mean, normal people have jobs, they work 8 to 10 hours a day, they have kids to take care of, they commute, they are busy 15 hours a day, and when they just want to get informed, to be good citizens, to read an article in the press, they don't want to go through their choices. And I think what we're discussing here are harms for democracy, are enormous power structures. And we want to rely on the consent that people feel they are giving, whether they can be shown, a pair of sneakers rather than something random. People don't understand the implications, and it's not right to ask people to understand those implications. You talked about mergers before. It's like saying, well, the merger between Alstom and Siemens, let's see which kind of trains people will be taking. That's the same kind of thing. It's a structural decision that has to be made by policymakers who understand all the implications, and that's us, basically. And you can't just leave it to normal people who really are not obliged to understand all the implications of digital advertising system and the Google monopoly. That's the basic asymmetry. That's a very structural decision, which is to be made by policymakers and people who are paid for understanding that. And we delegate all this complexity to people who think they are deciding, well, can Google or whoever or the New York Times show me a pair of sneakers rather than something random? That's the decision people are making. And that's the basic problem with all these very individual solutions that were fine when GDPR was planned in a world that was not controlled by two big companies, basically. But now we don't have a choice. And how, what do? I went out to a bar a couple of days ago and wanted to get a drink, and I had to scan the QR code to see the menu. In order to see the QR, to scan the Q to see the menu, there was just one option: allow all cookies. So I complained with the waitress, and she said, well, I said, this is illegal. And she was like, go get your drink elsewhere. And this is actually exactly, and how many people would get up and get their drink elsewhere? Nobody does, And it's the same thing. It's always, there's a power issue. And however you devise it, they'll always find a way to make this form in a way that it's too complicated for people to understand. How do I know whether the partners of that publisher are whether I can trust them? I mean, the publishers don't. And the publisher told me, well, we get this form from the Data Protection Act agency, and we found out we had 450 partners. Among them were three Chinese companies we had never heard of. We tried to write to them because we have to give the data to our Data Protection Agency, and they told us they have no business in Europe. That's the kind of people who get the data. How am I, as a normal user, supposed to know whether that's a reliable partner? This is a parallel universe. This is not the world people live in. Sorry.
Yeah, quickly, because we have to turn to questions.
Okay, so the only alternative is to have a regulation that controls the ecosystem.
I mean, I think what you're hinting at, Alexandra, as well, is that any kind of solution needs to be quite comprehensive, right? Because you're not just dealing with competition, you're not just dealing with privacy, you're dealing with all these things together, as well as the user-facing issue, the design-facing issues that are more connected with digital literacy, how much time someone has, cookie fatigue, things like that. So it's the kind of thing where having policymakers deal with it alone is very, very difficult, right? Because you can make a law, that's a such and such, but in practice, these issues are so complicated that to get it right, you do have to have industry involved. You do have to have, some kind of some kind of format, for policymakers and industry to kind of work things out together. No, says Johnny.
So a quick one.
I said the wrong thing. Now we won't do questions.
A quick one. The problem is that personal data is being thrown around the place with wild abandon. We know what the systems are. The rules of those systems have been published in public for years. We know who's legally responsible. And we also know that if you didn't throw around personal data, you could throw around non-personal data. And actually, that would work pretty well for some sort of relevance and so on. And you'd solve an awful lot of industry problems. Just, you wouldn't solve problems for the intermediaries. They would lose money. The answer there is not to lay down new sedimentary layers of new digital law, yet more silting to the bottom, left neglected. It's to apply the law we have.
That's certainly a fair perspective. I want to turn to questions. I see a line in front of, I see a person here. I don't know how this works. Maybe the person in front of the mic seems like they were standing for a while.
Well, thank you very much. I actually don't know where to start. Like, there's so much in this. First of all, thank you, Nick, for organizing a great panel, and also thank you very much for responding of Johnny's skepticism about things not working out and giving the examples of the none of your business NGO fighting back Meta. And I think it's very important in the entire discussion to because everybody mentions it's a power issue, but it seems that we forget that the power is about narrative. And even in this room, even in this field, even you, Nick, who were arguing against Johnny, in our narratives, we not arguing but disagreeing with him. You were bringing forth the narrative that says that these two companies maintain power. And I find it a bit difficult because personally I believe that we're in the transitioning stage. And if we don't see it that way, and if we don't, even in our discussions, in our the way we speak, we're not careful to make this clear, this transitioning stage is going to go nowhere. Right, because we have a person from the Commission, person from the European Parliament. These are the people who actually collect the political will, and if we don't gather that political will, the enforcement is not going to happen. And I think the laws, the boundaries of this practice have been already set in 2008, 2009, maybe after GDPR very strongly, but it's the political will that enforces those boundaries that is the problem. So my question to come to, and I think I want to address this to all of you. I'm just curious to know, where do you think is the status quo right now in terms of the Adtech infrastructure? Do you think it has changed? Do you think it is changing and it's transitioning like I believe so? Or do you think it will ever change? So just to measure where is your belief system with regards to that? Yeah, thank you.
Who wants to take this one?
I mean, I hear there's a new version of the transparency and consent framework. There's no change that I'm aware of.
I don't think there's much change at the moment, but it is a bit early to say because we've got two big pieces of legislation, the Digital Markets Act and the Digital Services Act, which do, certainly the DMA addresses gatekeeper problems and tries to redress some of the imbalances. The proof of the pudding will be in the eating, as always. And I think the opportunity to really stop data combination and cross-use was missed, really, by including the ability to get consent, which just really replicates the status quo, although there will be more scrutiny of it. So, and you were talking earlier about advertiser transparency of where their ads land. Some of the data-related obligations under the DMA allow publishers and advertisers to get information about the ads. Who knows how granular that will be, how it will be delivered, because the DMA workshop you referred to last week didn't actually talk about the solutions.
Yeah, we have a few more people in line who look interested in asking questions.
I have two fairly short questions. One to Angela. If obtaining consent is so hard, why have the publishers refused?
Sorry, could you also identify yourself?
Oh, my name is Walter van Holt. I'm with Every Member Vrijschrift. And I have two fairly simple questions, one to Angela, one to Peter. The question to Angela is, if obtaining consent is so hard, why have the publishers refused to implement the Do Not Track standard, which basically never went out of the gate because it was never adopted by the publishers, which accommodates all the complexities the panel just discussed. And my other question is to Peter. If you care so much about the gatekeeper role of the browsers, why did you allow Google to basically capture over 95% of that market? And by not enforcing the existing rules in the GDPR that say if there's a technical test standard available about opting in, opting out, that should be used. If you had enforced that, then there would be more space for browsers to differentiate themselves on privacy. So I'm looking forward to your answers.
It's not a very popular answer, but I have no idea how to answer your question.
On the enforcement, as you probably know, the enforcement of GDPR and e-privacy is by national authorities. So it's not, the Commission cannot enforce.
This is a competition question. This is not a GDPR question. Why would you allow them to capture the whole market? That's a competition question.
Well, it depends. They haven't acquired the market position in browsers through acquisitions. They acquired it because the users took it. So I think there is difficult to intervene with antitrust law against a market position which is not acquired by mergers and acquisitions. What can be intervened against is abuse of a dominant position, and there the colleagues in DG Comp are working on such cases against Google.
We have a few more people in line. There's someone raising their hand here, but. So
could you summarize the question?
For the audience, how do we make essentially complying with the law a kind of more profitable kind of thing? How do we incentivize people? How do we create an incentive for companies to comply with the law rather than stick with the status quo?
You robustly enforce against them. It's not our problem to solve.
Nobody can hear you back here.
Yeah.
And there's also a line waiting for people.
Yeah. Okay. Sorry. Yeah. Okay, we only have 5 minutes, so maybe I'll just go through some more questions over here.
Baron Soga, NGO called Tech Freedom. My question is for Alexandra. Thank you very much for calling attention to the concern of brands who don't want their content, their products to appear next to hate speech. I think we can all agree that bare minimum that we could expect is to channel that market force for good to ensure that they're not supporting bad content. I'm a little confused as to what the problem is. You're absolutely right that the tools were not very good for a very long time. In 2020 and 2021, the big ad platforms did offer new tools. Google offers a tool that allows brands to use dynamic exclusion lists that can be supplied by Google. They have a default list that recommends hate speech and other content that can be blocked. But also the brand can choose any other ones. They can provide their own dynamic exclusion list. They could subscribe to a dynamic exclusion list that's created by a third party. The Greens, civil society groups, anti-Semitic groups dedicated to combating anti-Semitism could create their own lists. So my question for you is, what is the problem that you see? Is it that the tools that are offered by Google are not good enough? Is it that other companies don't offer better tools? Is it that the tools don't work together? Is it that the companies are not using the tools? Is it that civil society is not helping to create the tools? Because there are some tools there. So how do you see us empowering brands to use their market power to stop funding hate speech and misinformation online?
Yeah, first of all, I don't think it's the task of civil society to spend their free time and non-paid time to come up with tools to counter the harms that are caused by a profit and very profit-based and extremely profitable model just on civil society. On the brands, I don't know whether they don't use the tools or whether the tools are not good enough. I can only say what they have been telling me and what the World Federation of Advertisers tells you as well. They say, we have our guideline, we have our lists, and we are not able to make sure that Google and Meta really abide by this. We keep finding our ads on websites where they shouldn't do. I'm not an expert of the sector from a business point of view, so I can't tell you what exactly the problem is, but this is what the brands are telling me. And I think the basic problem is, that's what Johnny explained, that advertising follows people around the internet, and for Google and Meta, it's a lot more profitable than to place the ad with one person, with one user, not when they are on the Financial Times website or the New York Times, which is probably pretty expensive, but rather when they go to porn.com or trash.com, where it doesn't cost anything. So it's an economic incentive for the intermediaries to place that ad where it's cheaper. And I think there's a business incentive to do that, and this makes it probably so difficult for the companies. How could they leverage their power? I think promoting contextual advertising, because there they have full control over the websites. Then it's the website and not the person, and therefore also the transparency system is a lot easier to read for companies.
Thank you. We have a few more. I see Kasia from Panopticon standing over there. A very short question, because we're running out of time.
Thank you. I will try to make it short. A question to Angela. How would publishers react to potential new regulation that on one hand makes consent no longer necessary because it could legitimize advertising as something legitimate, in fact, without consent, but on the other hand, prohibiting the use of any inferred data. So advertising without consent based exclusively on data provided by the user. Would that approach be accepted by publishers? Thank you.
Well, I think in the European Publishers Council, we're looking very carefully at what kind of regulation might actually change the dynamics that we have today. And I think having some sort of regulation which creates less burden on the user is really important, because at the moment they're treated as data subjects, as not consumers. And I think really if we can shift that more to a regulated market, you don't have to give consent every time you get in your car. I consent to drive this car. You accept that it's safe as long as you look after it. So I think there is something around that. And then certainly when GDPR was being discussed before it was passed into law, certain types of advertising were assumed to be going to be permitted under legitimate interest. So, I think if we could get back to that kind of paradigm, I think that would be helpful. The inferred data, I think this is out of the box now. AI is doing this all the time and will continue to do it. So, watch this space.
Peter?
Just one comment on this idea of legitimate interest to permit advertising. I think that has been in the e-privacy in 2002, it was changed, and I think we don't go back to legitimate interest for advertising.
We don't go back there because advertising became so intrusive because of the reasons Angela just described, the AI-based inferences. But if we could come back to advertising being predictable and controllable by the user becoming data subject, then maybe we could go back also to that paradigm. So these two are interconnected.
I think it's an interesting point about the notion of if users had complete control, complete transparency, then the market could look a lot more different, right? It could be more permissive, right? Because the user would have full control, right? Or you would at least consider something like that. We have a few more people standing in line. I'm very sorry, but we are out of time. So I'm sorry, you've been standing there. I wanted to thank you all for attending this panel, and I wanted to thank all our panelists for a fantastic discussion. I want to invite you all in joining me in giving them a hand of applause.
It's the time of the year for this event for the Commission because you guys are